Welcome everybody to the Australian New Zealand Rhinologic Society webinar series. Tonight, the series or the topic is on law for the rhinologist. We've got a bit of an all-star cast. So tonight we're actually joined by two lawyers and three ENT surgeons with experience in medical legal consulting work. Our first lawyer is Natasha Gallace. She's actually a corporate counsel for Getty Images. And she's actually got a really interesting background. In particular, she's also got an interest and a passion for photography as well. But I asked Natasha to talk based on her experience in social media and her experience as a lawyer for Getty Images. And our next speaker is Ellie Theodore, who's a special counsel at TEGO in medical indemnity insurance. She's actually got a really interesting background as well, in that she studied criminology and psychology before then going on to do postgraduate law. And Ellie has quite a lot of experience with medico legal work. And then after Ellie and Natasha have presented, Alki Soltis is then going to move on, and we're going to be joined by Richard Harvey and PJ Wormald, who are going to talk about their experiences in medico legal work. So I'll stop sharing and I'll hand over to Natasha.
Great. Thank you very much for the warm welcome. I will just get my slides up and hopefully, there we go. Hopefully you can see those slides, but just let me know if you can't see them. Excellent. Okay, so good evening, everyone, and thank you all for attending this Law for Rhinologist session. I appreciate the opportunity to join you and contribute to what I hope will be a practical and insightful discussion. Before we begin, I would like to give you a quick overview of what we'll be covering this evening. Given my background and expertise in intellectual property, we will really focus on content considerations because it can be quite complex to navigate in understanding what you create or use or share to promote your professional practice and services. Very layered. There are also a number of consumer laws and APRA regulations that need to be contemplated in this space so that we all have a solid and clear understanding of obligations to patients when it comes to advertising and how these might interact with confidentiality and other professional conduct standards. Throughout the session, I'll highlight some of the more common pitfalls that practitioners may encounter and hopefully offer some practical tips on how to avoid them in your own practice and management. When using content such as images and videos in your professional practice, whether it's for social media, websites, educational materials, or promotional purposes, it's important to be mindful of the associated rights that are attached to that content. You need to think about the copyright that subsists at the content creation level and be very clear on who owns the rights and whether you have the permissions to use the content. If you are using content that you personally created, for example, a photo or a video that you shot yourself, that's ideal because you will be the copyright owner of that content. Unless there's an employment agreement or some other work for hire arrangement in place that might state otherwise. But in those cases, you will be the copyright owner. And because you are the copyright owner, you reserve the full rights to use and repurpose and control that content. And this is because the copyright owner maintains the proprietary right to control the content that they created. And only they can exercise those rights or grant permission to others to use that content. However, if the content has been created by a staff member that might work for you, it's a good idea to ensure that your employment agreements clearly state that any intellectual property created in the course of their employment is assigned to you or your clinic or your business. Otherwise, even though the content may have been created under your direction, legally the staff member might retain ownership of that content. So it's always best to have explicit documentation in place. If you choose to source content from external providers, whether that's a photographer directly or a stock content platform, make sure that you have the appropriate licenses or permissions in place to use that content. A myth that I often find myself debunking is that if content is on the internet, it means that it can be used freely, or that if you credit or attribute the creator, that's sufficient. Well, generally, that's not the case. You do need those permissions and licenses in place. And then once you have secured a license, please do read the terms and conditions carefully, just to confirm that the way you plan to use the content is covered off by those terms and conditions. For instance, if you're using an image on your website, that might be permitted, but using it in social media could actually require a different license. But most royalty-free licenses from stock content providers will give you very broad rights to use content on any and all platforms, but still really good to be aware of the terms that are attached to using that content, particularly if there's any expiration dates for those licenses when you might need to take that content down or relicense. We're also increasingly seeing clinicians and practitioners turning to AI-generated content. And this can be a powerful and efficient tool, but it can come with its own set of legal grey areas. So if you want to use an AI generator tool, my advice would always try to make sure you are using a trustworthy AI provider who will provide you with warranties and indemnities, and who don't inadvertently generate images or content that might actually resemble a real public figure, like Taylor Swift, for example, as that could then introduce serious risks around likeness rights and misrepresentation. And hopefully we don't have anyone who is right-clicking and using images off a Google image gallery or other content without proper permissions in place, because it could certainly get you into hot water when it comes to copyright infringement. So beyond copyright ownership of the content itself, it's also important to consider what is within the content. Even if you own that photo or video or have a license in place, you still need to think about who or what appears within that content, including any patients or staff or branded items or clinical settings, and how and where you plan to use that content. Let's continue to explore and evolve these ideas a little bit more. When looking closer at what is within content, you need to pay attention to any people that might appear within the content, as well as any properties. It could be your specific clinic. It could be a hospital. You might also be thinking about using images that are indicative of a geographic location, like the Sydney Opera House, to show that you might have practice rooms in Sydney, for example. And lastly, any trademarks, particularly any medical or pharmaceutical brands or logos. So if any of those things might be within the content that you want to use, you'd need to think about obtaining releases. Something else to keep in mind is that you might not always be able to get those releases. For example, a big pharma company or brand might not sign off on allowing you to use their branding in your advertising, which I, of course, understand because they're going to have protections around their brands. But sometimes you can actually employ techniques like scrubbing out logos, photoshopping a logo out to make something a lot more generic or non-identifiable. Likewise, with the Sydney Harbour image that I was talking about before, if you're going to use an image of the Sydney Harbour, make sure you're including a full skyline shot with many buildings and no particular focus on any one building, and certainly not the Sydney Opera House. By doing that and including that full cityscape, you're certainly reducing your risks there of a valid claim. But if you were to crop an image or you were to focus solely on the Sydney Opera House, you will likely hear from the Sydney Opera House Trust. They are very vigilant when it comes to using images that feature the Sydney Opera House. Coming back to the releases topic for the moment, If you are using your own patient shot content, you would want to make sure that you have a written and signed release document in place that says their image or their likeness can be used for any and all purposes, including but not limited to your advertising, and that the release applies in perpetuity and that it cannot be revoked. Those terms are going to give you that tightest form of release. I've seen plenty of releases over the years which have had a more narrow application of applying for a certain time period or in connection with a specific purpose or platform, which might be fine. It might do the job that you are after, but it's certainly not giving you the broadest set of rights. And let's be honest, if you have rights to display content for a certain time period, say 5 years, are you really going to remember to remove that content 5 years later? I know that myself personally, I'll probably forget about it, and it could bring about unnecessary issues. Doc providers are also a very helpful resource, as they have often done the legwork for you and have already secured all necessary releases and have ensured that the content is clean for commercial and advertising uses without the need for further permissions. Stock providers will often also go that step further and provide you with warranties and indemnities if there is a problem. So my recommendation when you're wanting to use content is always look for a provider that's going to have your back if there is a claim by giving you that indemnification and picking up the claim so you don't have to worry about it. Lastly, on that slide there is a reminder about minors that a parent or a guardian need to sign on their behalf. I've also experienced issues before where the person signing as a guardian was not actually a true guardian. So just be careful there, and in any releases, make sure there's thoughtful language about the parent or guardian who is signing, that they're warranting to you that they're going to be the correct person who's signing on behalf for that minor. Okay, I'm going to share a couple of examples of images that might need not only permission from the copyright owner of the content, but also releases for what is contained within. So in the first image, this is very generic and doesn't need additional releases, but I do want to call out that if there was an Apple logo or some other branding on the computer or on the medicinal vial, permissions would need to be in place for those as well. In the second image, the location is quite unidentifiable. So the location itself would likely be okay without a property release, but a release would definitely be required from the person who appears within it. And if there was any branding on the vending machine, for example, just say the vending machine had a big old Coca-Cola logo on it, that could be problematic for you. And to throw something else into the mix, sometimes it's not just the branding or logo that is protected. It could go further than that. The Coca-Cola glass bottle shape is protected by trademark. So even if you were to scrub off the logo from the glass bottle, you could still face issues. Image number 3, the people, even though you can't see their face, their surroundings can make them identifiable. So for that image, you would need to have a model and property release in place. And then for image number 4, you of course have a minor issue, but also the other person requires a release. But then also think about other branding that might appear within the content. For example, would there be an Adidas logo on the shoe? This content on this slide is all royalty-free. It's all fully released stock content. So it's taken the headache out of figuring out what needs releases, what needs scrubbing. And so this is all available for commercial uses. But I hopefully, after seeing these examples, you can be mindful of the copyright of the content and all the things that might exist within. Now that we've talked about the content itself, let's move to where you are using content and any rules that you might need to be thinking about. The most common places that you might use content will be, of course, websites and social media. And when using content on social media, it's really important to understand the platform's terms and conditions. And this operates twofold. First, consider the rights that you're granting the platform simply by uploading content. Many social media platforms include clauses in their terms and conditions that give the platform broad license rights to use and modify and distribute your content, sometimes even globally and on that royalty-free basis. So before you post something, just be aware of what you're agreeing to and how your content could actually be used beyond your original intent. Second, be mindful of the platform's own rules on advertising. For example, if you're promoting a service or collaborating with even an influencer to have a wider audience reach, make sure that any promotional content is properly disclosed as so. Posts that are paid for or sponsored need to be clearly labeled as such, not only to meet the platform's policies, but also to comply with consumer laws. This ties in closely with APRA's regulations, which apply to content shared on social media. So I highly recommend that everyone go and read those regulations and guidelines in full. And under these guidelines, any claims that you make in your posts, whether about treatment or outcomes or qualifications, it needs to be entirely accurate and evidence-based, so from reliable or relevant sources, and it must absolutely not be misleading in any way. You must be extremely careful not to create unrealistic expectations through the way you present your information or imagery. And if you're posting content from patients, you need to ensure that it complies with both APRA's advertising standards and privacy principles. So whilst social media can certainly be a powerful tool for connection and education, it might also carry risk of breaching professional obligations only if the content and the information associated with it isn't curated thoughtfully. So just be very thoughtful about how you're presenting your content. The APRA social media guidance for health practitioners also emphasises the importance of maintaining professional standards and ethical conduct online, just as you would in any face-to-face interaction. I'm sure we are all well aware of a couple of TikTok nurses who, let's just say, went beyond their board's expectations when it comes to code of conduct. So we just want to make sure that nobody is falling foul there. I've touched on truth in advertising, but I really do want to reiterate and highlight the impact that advertising can have on public safety and public trust. It's absolutely crucial that all advertising is truthful. If you're using content featuring doctors' work that may not be yours, disclose that. Always err on the side of frank disclosure. If you're using content to explain a particular procedure, but the person within that content hasn't had that procedure done, make that clear. Say that the content is used for illustrative purposes only, and that the people appearing in the content are models. By using that disclaimer language, you're not misleading the public to believe that these are the results that they're going to get and that's the work that you did. Make it clear that individual results may vary. All of these things are going to help the public at large make more informed decisions and choices and will keep you on the right side of the law. The other thing I want to raise is how to deal with patient testimonials and negative reviews or comments. You may each, of course, have your own way of dealing with these concerns, but my personal preference and recommendation would be to firstly assess the legitimacy of the concern, sometimes responding with a very short, polite, factual explanation may be appropriate. You have to be super careful when responding publicly that you don't incidentally divulge any confidential information. And we will look at that in more detail on the next slide. In all cases, being defensive is probably not going to help. And it also might be a case where it would be a good idea to get some guidance from your medical insurer or legal advisor, or perhaps your practice manager for some further context. I also personally find that responding as soon as possible tends to alleviate and reduce the tension a little, because the aggrieved then feel heard. It might not entirely diffuse the situation, but can definitely lead to a better result. My recommendation whenever there is any sort of commentary out there in public forums is really to direct that conversation to resolve amicably outside of that public forum, so that no sensitive information is inadvertently shared. If a Google review violates any of their policies, you can also report that to Google to have it removed. But remember that that review needs to be one that breaches their policies. So, for example, it might be a fake review or irrelevant and spam-like. But if the review is just negative and more factual or personal opinion, the likes of Google will probably not remove that without a policy violation. If some of those comments are truly disparaging, you might also have a right of recourse via remedies via defamation if a review is untrue or disproportionate or unreasonable and malicious. But you might want to weigh up whether you want to be involved in legal action to begin with. It can, of course, bring about negative perception and publicity that you just might not want. And of course, the time and cost involved in that, certainly not something I would recommend, but of course, each set of circumstances are unique and different. Another critical area that I want to highlight is confidentiality, and never disclosing a patient's private information without their consent. It's not just limited to clinical information, but also relates to anything that might make somebody personally identifiable. It's not just a patient's name or their photo. Personally identifiable information can include things like their age, gender, location, who their employer is, or even more subtle details like the date or time of consultation or surgery. These elements, when shared, even when shared separately, or might seem vague, they can often be pieced together to identify someone. For example, the description of a 44-year-old female marathon runner with asthma living in the Northern Beaches who visited my clinic. That might identify someone. Another example could be referencing a unique injury or an unusual procedure or a very specific appointment time, especially if it's a small or close-knit community. That could easily make somebody identifiable as well. This can also extend to information about waiting times for their consultation or payment types for their consultation. It may hint at a patient's financial or private health or workers' compensation insurance status. So the rule of thumb is just don't discuss any patient information outside of your secure office or rooms. And even avoid discussing patient information, even in places like the hallways of your practices, as sensitive information could be overheard. You also need to be vigilant when it comes to securing medical records, making sure that files or computer systems are password protected and that physical files are locked away in a non-accessible area. I can't tell you how many times I've seen passwords written down and then stuck onto a computer or a work desk or written into a diary, or the same password used for multiple systems. It's not particularly secure to do that, and we certainly want to avoid any breaches when it comes to confidential information. That is all the information that I wanted to run through this evening, but certainly happy to take any questions either now or at the end. I'm not sure, Raywin or Ray, how you would prefer that to be taking place.
Thanks, Natasha. I think it'd be great to have maybe one question now, and if you're happy to stay on, it'd be great to have a discussion after Ellie as well.
Of course.
There may not be a question yet, but if anyone does have any questions for Natasha, please speak up now.
Can I ask Natasha?
Of course.
Although breaches in confidentiality, I might have missed the first little couple of slides on your talk, but breaches in confidentiality may result in complaints. What percentage of claims for financial compensation do those account for out of total claims?
That's a great question. And I want to say, I don't know, Ellie, if this is something that might be more in your wheelhouse than mine. So I might direct it to you if that's okay, because you're nodding there.
Look, I've been in the field for a while, and I actually haven't seen any successful compensation claims from a patient to a doctor for breaching confidentiality in the terms that Natasha was speaking of, or the other way with defamatory action being successful against something like a negative review. So I actually haven't seen any.
We might now move on to Ellie. Please, if you have questions, Ellie and Natasha, we're going to have a little bit of question time after Ellie's presentation as well. So hold on to them. Ellie, over to you.
Okay. I hope everyone can see the slides.
Yes, we can.
So I thank you very much for inviting me to speak today. And I'm keen to talk about the common pitfalls and areas of vulnerability that I see that come across my desk the most often. So first, do no harm. What's next? I hope you like the title. I'll move on to, okay, so regulatory action is by far the most common case that crosses my desk. By this, I mean complaints, notifications to the medical board, AHPRA, and its associated state healthcare complaints entities. For example, in New South Wales, it's the healthcare complaints entity, and in, for example, Queensland, it's the Office of the Health Ombudsman. So complaints to AHPRA have trended upwards each year consistently for a number of years. In 2023-2024 annual report, AHPRA received 11,207 complaints, which was up 15% on the previous year. That figure does go across different boards, medical, dental, pharmaceutical, other types of boards too. But if we focus in, there's still a huge number of complaints being nearly 8,500 complaints made about medical practitioners. It's worth noting just at this point that with respect to patient complaints to regulators, there actually isn't a triaging service to weed out any complaints that sort of don't have any legs. So it's actually a statutory requirement that the body that receives the complaint, so be it the Healthcare Complaints Commission or AHPRA, they actually have to accept the complaint and then invite the practitioner to respond, and then they will assess the situation. And it happens time again that people are, to use a kind of vogue word, keyboard warriors, and they have a bad experience and they will jump online and see, wow, it's really easy for me to make a complaint. And here I go, I'm going to lodge a complaint. It might just have nothing to do with clinical care, nothing to do with anything, but you still will be invited to respond. And that is due to the overriding principle of protection to the public. So the most common causes for notifications are communication, issues surrounding communication, clinical records and documentation, boundary violations, medication, and clinical care. So this evening, I just want to zone in on a couple that are the most prolific that come across my desk. So first of all, communication. Is it true? No notes, no defense. Boundary violations, doing favors for mates, and where do you draw the line? And it is not the subject of an APRA notification, but I do also want to tack on a quick piece about AI, healthcare, and the law, because it's very topical at the moment. And I know lots of people are hoping to use it for its benefits, but I just wanted to point out a couple of things to maybe build slightly on what Natasha said. So communication. I'm just going to go straight into a real life example that I have just closed a case along the following lines. So when we're talking about communication, the key thing we're talking about is informed consent. Assuming that consent provided is fully informed and voluntary, and the patient has been given other options to the proposed treatment, if there is a different option, and elects to proceed, then generally the risks identified as inherent risks are not actionable if they eventuate in the healthcare provider, if it does eventuate that the healthcare provider has acted with all due care. So I recently had a case in which a specialist surgeon received a notification of a complaint made to APRA, which had a range of different factors to the complaint, but I'm just going to focus on the communication and consent issue. The patient felt aggrieved and essentially alleged a lack of informed consent after allegedly finding out post-procedure that the specialist surgeon had not actually been the one to perform the surgery, rather it had been performed by her fellow under her supervision. And I've popped the wording that I've taken directly from the complaint here, that the complainant says, I was told numerous times that my procedure would be performed by Dr. X, who is my client, and I was seen by Dr. X prior to surgery, and I also saw her when I was wheeled into theatre. It wasn't until after I had woken up from anaesthetic that I was informed the surgery was actually done by a fellow doctor who had arrived into theatre after I was put under. If I had known it was not Dr. X, I would never have gone ahead with the surgery. I feel completely deceived, and I am left with unnecessary and excruciating pain that very likely would not exist if the surgery had been performed by Dr. X, a far more experienced surgeon. So the background to this is the patient consulted Dr. X privately in rooms. Dr. X discussed the proposed procedure and explained the associated risks. Dr. X made a recommendation for surgery at a public hospital. So the patient was then provided with a written consent document, which explicitly stated that any surgeon at the public hospital may perform the surgery, including a registrar fellow who may be involved with the procedure, but with a primary surgeon supervising. The patient was booked in at the public hospital for the procedure by clerical staff. So there's all kind of normal stuff that goes on. The alleged lack of clarity in this case is what affected the patient's understanding and her perception. So this is despite the fact that she signed paperwork that said that it may not be Dr. X performing the surgery. She alleged that she did not understand that it might not actually have been Dr. X performing the surgery. This arguably led to the patient making the leap that her alleged poor outcome was actually the result of a fellow being involved as opposed to Dr. X performing the surgery. I just wanted to kind of make a second point here that I was reading into a few studies on this, and there's a study that noted 80% of medical information provided during a consultation is instantly forgotten by the patient. And this complaint is a good example of that. Dr. X did explain to her that it would not be her necessarily that would be doing the surgery, but it would be either under her supervision or someone of her caliber's supervision. But the patient in her complaint says that didn't happen. I don't remember that at all, despite the fact that she signed something. So how can we improve on it? And what practical steps can we take? My suggestion would be record all advice and warnings, including the ones that you routinely provide. Combine communication and documentation. Maybe if you're using a diagram or a written document to facilitate explanation, provide a copy of that to your patient and make a note in your records that you gave that document or whatever it is to the patient to take home after you had discussed it. Another issue could be to confirm the patient's consent by confirming their understanding of the procedure, including what will happen during and after the procedure. This may help avoid a misalignment of expectations and ensure that there's informed consent, and record the details of that discussion in the clinical notes too. And I'm not blind to the fact that my suggestions all make things more labor intensive in terms of taking notes and doing all these things, and I know everybody's really busy. So I did read a helpful article that said consider using a macro to help improve efficiency of record keeping, which could also help as acting as a prompt to remember things to discuss. So that could make things more efficient. And when I talk about AI and the use of AI scribe in a couple of slides' time, then I can speak more on that. So going back to Dr. X, the same complaint alleged that in the post-operative period, the patient was offended by 6 words that she allegedly did remember the practitioner said, which was, Dr. X told me that the alleged outcome is probably a bit of bad luck, which is completely unacceptable given the circumstances, and that Dr. X allowed a fellow doctor to perform my procedure without my knowledge or consent. As I said, I would never have elected to have this surgery if I was made aware that it was not Dr. X performing it, but it was to be by an inexperienced fellow surgeon. Of course, this fellow was not inexperienced, but it was the perception of the patient that this was just a junior. So in this case, Dr. X specifically remembered this patient because she had had a complicated post-op period, but had resulted in consistent complaints of chronic pain post-operatively. And Dr. X, my client, was able to recall that she actually did say something along the lines of chronic pain as a result of surgery is a bit of bad luck. But to the patient, the statement was unprofessional, it was dismissive, and it trivialized her situation. But to the practitioner, these words were simply an expression of frustration that were directed at not being able to find a clinical reason and solve the issue of the chronic pain, which left her feeling frustrated. However, that was not the perception that the patient had. So I just wanted to also touch on another piece of research that I found, that at an international level, some researchers identified that there is a strong correlation between rude or unprofessional behaviour and the likelihood of a complaint. And local level analysis in Australia reveals that a doctor's behaviour is often raised in the context of a clinical concern. If a patient perceives rudeness or arrogance, which, and I know I'm talking to surgeons now, but which is a common complaint, particularly for surgeons, it could be a signal that the patient actually doesn't understand something, including expected outcomes or post-op period, or they felt unable to ask a question or seek further explanation. So that's just something to bear in mind, and I'm certainly not making any assumptions about anybody. On another level, the medical board, so ARPRA, could perceive that complaints that are related or about rudeness or dismissive attitude or disrespectful behaviour to patients or to colleagues, say in theatre, this could be, the medical board may think that this is indicative of stress, burnout, mental health or physical health problems for a practitioner, which then presents as a risk to public and patient safety. So those are the sort of things that they will focus on if they communication and particularly rudeness comes up. So yes, choose your words carefully. And so back to Dr. X, and the outcome was exactly what we wanted, which is no further action. And this was by a well-drafted response. And she had comprehensive clinical notes and consenting process, and it was all thoroughly documented. So we got the outcome we wanted there. So moving on to my next point. So no notes, no defence. Is that true? So just to get to the nuts and bolts of what is professional negligence, there are actually 3 elements that a patient, if they were going to try and sue you, has to be successful in proving all 3. 1, a duty of care is owed. That one's pretty obvious because it's a doctor to a patient. 2, there was a breach of that duty of care, and that breach of duty of care caused an injury to the patient. So I'm going to again focus on the importance of clinical record keeping and how this plays a role that is crucial in defending claims. Another case that I have that's on foot at the moment involves basically a factual contest concerning clinical notes. Patient A was taking blood thinners prior to a procedure performed by Dr. Y. Blood thinners were contraindicated for the procedure in question. As a part of patient A's case, she alleged that Dr. Y did not ask her about the use of blood thinners prior to the procedure. Therefore, it is her case that Dr. Y has breached her duty of care by failing to elicit this information and consequently to defer the procedure because there was a compromised outcome. But it is Dr. Y's position that she did ask about the use of blood thinners and received a negative response. Further, it was Dr. Y was confident in her standard practice, which was to always ask about the use of blood thinners prior to a procedure, and that she would not have performed the procedure if patient A had confirmed the use of blood thinners. So Dr. Y noted that it's her standard practice to document negative findings only. However, in this instance, in the clinical records, there was no mention of a negative finding or no mention at all. This is problematic because patient A may have failed to disclose that she was currently prescribed and taking blood thinners, but there is no way for Dr. Y to test that information. The critical issue for Dr. Y is that the clinical notes did not record any mention at all, positive or negative. And the reality for this case is, on balance, that the lack of clinical records means it's only going to be a tool for settlement negotiations as opposed to having any meaningful argument on liability. But for this one, the case continues. We're still going on with that one. Then I just want to talk about a decision that makes helpful comments about clinical notes. It's a New South Wales decision from the District Court, Supreme Court. The facts are kind of complex, but a very short version is Dr. A.B. carried out a procedure on the patient's left eye at the Sydney Eye Hospital in 2015. The plaintiff claimed to have lost vision in his eye and suffered ongoing pain and psychiatric damage. A significant issue in the case was whether Dr. A.B. inserted 7 needles in order to aspirate the vitreous, or whether he ceased the procedure after no more than 3 needles. In this regard, a very unfortunate aspect of the matter is that there were no notes whatsoever of the procedure that was carried out by Dr. AB. The outcome of the case is actually a verdict for the defendant, with the trial judge accepting the evidence of Dr. AB that he did not attempt more than 3 injections to withdraw fluid from the patient's eye. And interestingly, the judge made the following comment, which is up on the slide there. It's difficult to see how a doctor could owe a duty to a patient to make notes of what the doctor said or did. It may be a breach of the doctor's professional responsibility, although no evidence was led in that regard, meaning that neither party brought any evidence either way on that. And it may at some future time result in liability because the doctor did not treat or advise the patient appropriately as a result of not having a record of previous advice or treatment. Similarly, a failure to make notes of advice or treatment may mean that where there is a conflict of evidence, the patient's account will be preferred over that of a doctor. Neither of the two situations posited above suggest that a failure to take notes in itself is a breach of duty of care towards the patient, which is quite an interesting stance. In cases that there are no clinical notes to rely on, lawyers will typically ask the doctor what their usual practice is and seek to rely on it. And in this case, this is a very helpful passage from the judge as he went on to say, a statement that someone never did a particular thing is a stronger statement of usual practice than a statement that a person always did something in a particular way. It has a greater force when there is a plausible reason for never doing the thing. And in this case, Dr. AB gave 2 plausible reasons for never having tapped the eye more than 3 times. He had been taught not to, and that there was little or no point in doing so more than 3 times because nothing is achieved and the patient is likely to be distressed. So talking about practical steps, in terms of clinical notes, again, make sure documentation includes all clinical findings, but also all the advice or information given to the patient, including that you routinely provide. Document procedures and operations, including all steps taken. And I'm talking about the actual operation report. And even if this means even if you want to put usual procedure followed, because that still gives one grounds to say, well, my usual procedure is X, and here I've written usual procedure followed. And I guess the test that I'm sure everybody's heard before, if another practitioner stepped in to perform the procedure, would your clinical notes alone have enough information to enable a takeover of care? Just briefly wanted to touch on the importance of clinical notes and Medicare, and then I'll stop talking about clinical notes. I have a case on foot at the moment, which involves started life as a Medicare audit, and I'm sure people are familiar with that. It's a computer-generated thing at Medicare where they'll find item numbers, and whoever's trending up or at the highest percentage, they get some documentation saying, hey, we seem to have identified that you've trended upwards with what you're doing, so can you explain yourself? So clinical records are critical in this regard. If Medicare audits a practitioner, they'll be looking at the use of the MBS item number criteria and whether the notes justify the item number used. And an audit can go nowhere if Medicare is satisfied with the content of the clinical notes. However, if they're not satisfied, broadly speaking, one would be referred to an interview to explain yourself. And if Medicare is still not satisfied, then it kicks in a statutory-based mechanism where there'll be a formal review of records, and they can go far-reaching into, say, 50 patients and look at a range of item numbers, and they will go hell for leather on it. So my other tip, which I would add to the current slide would be make sure that your records and your operative notes, operative report has enough detail that it can mirror what the MBS item number is looking for. And just a final note on that the case I've got on for at the moment is for a GP, and he's looking at paying Medicare back north of $500,000 because of overuse and misuse of MBS item numbers. So it's nothing to write off. It's definitely something that everybody needs to have some awareness of. Now I'm going to talk about boundaries and stop talking about clinical notes. So disciplinary matters are investigated and heard by the Medical Tribunal in New South Wales and equivalents in other states. Typically, disciplinary action arises out of the conduct of a practitioner, and whether conduct fell below relevant expected standards to be unsatisfactory professional conduct, or the more serious finding, which is professional misconduct. Both findings can carry suspension of registration or conditions on practice. The purpose of both is to protect the public. The Health Practitioner National Law establishes a national registration accreditation scheme, and the objectives are protection of the public by ensuring that only health practitioners who are suitably trained and qualified to practice in a competent and ethical manner are registered. And just wanted to underline ethical, because a common denominator of boundary violation cases stems from the inherent power balance between a doctor and their patient. And a doctor-patient relationship is always unequal. The doctor always has greater power, and the power imbalance is further tipped by inappropriate sexual contact or relations with patients, or making suggestive comments or actions, financial dealings with patients, and treating family members or friends with for example, the odd prescription here and there. So a recent case from the end of last year dealt with, it's a New South Wales case, and it involves allegations against a medical practitioner that the doctor had essentially encouraged a long-standing patient to invest around $300,000 in one of his businesses. And the second allegation was that he had accepted the money as an investment, and further took money from another patient who was related to that patient for investment. Then the practitioner employed that patient and continued the therapeutic relationship. And he was not honest or forthright in his dealings with these two patients, that either one of them or both had actually invested in the business. So the tribunal stated that the doctor should have been mindful of the risks and the boundaries that were being crossed, and that patient B's care could have been compromised when offering employment also. His judgment in offering the patient employment and continuing the therapeutic relationship was held to be significantly below the relevant standard. The tribunal found that the power imbalance between the doctor and patient B was significant. He exploited the power balance in their relationship by encouraging investment in his company and accepting the funds whilst continuing the therapeutic relationship and while she was an employee. The tribunal found that the doctor was guilty of unsatisfactory professional conduct and professional misconduct, and as such, he was not a suitable person to hold registration as a medical practitioner. If the doctor had been practicing at the time of the hearing and the decision, the tribunal noted that it would have cancelled his registration and disqualified him from practicing for 18 months. So that's sort of financial and employment boundaries. One here, another example that I think it had a lot of media traction a number of years ago, is, can I help with the odd script here and there to friends? This is unfortunately a tragic coroner's case from 2011 that serves as an example of the dangers of doing a friend a favour. Dr. JT was a GP and a family friend of over 30 years to the mother of patient W. The mother was not a patient, she was not a patient of the GP. Patient W was her son. Patient W had his wisdom teeth removed by a dentist, and he was advised by the dentist to use Panadol and other over-the-counter pain meds to manage his pain and to refer back to the dentist if necessary. So patient W commenced taking additional over-the-counter pharmacy medication, and one that contained codeine as well as paracetamol from the day after his surgery. He contacted the dentist the following day. So the surgery was on the 15th of June. So by the 17th of June, he contacted the dentist and was prescribed antibiotics for pain, but no additional pain medication. Patient W's mother called Dr. JT at home in the evening and asked that she could review her son and check out how he's going with his recovery, because he was still in significant pain. So Dr. JT saw patient W at her home that evening. She prescribed him Mesindol, and please forgive my pronunciation on these drug names, and gave him a box of 5-festone methadone, basically, that she had at home. And the methadone had been prescribed to Dr. JT following a back injury many years prior. So Dr. JT instructed patient W verbally to take 1 tablet at night, but she wrote on the box, take 1 tablet every 6 to 8 hours, and there were no notes made. Unfortunately, patient W was found dead 2 days later, and the coroner made non-inquest findings that the provision of the methadone was inappropriate, and it was inappropriately high, and she referred the Dr. JT to the Ombudsman in Queensland. The verbal instructions provided by Dr. JT of when to take the methadone tablets were inconsistent with the instructions that she wrote on the box of medication for patient W. The coroner noted that it was most probably unknown by Dr. JT that patient W had recently taken, again, sorry for the pronunciation, fluoxetine, an antidepressant medication. And the metabolite of this medication interacted both with codeine to make it less effective and with the methadone to prolong the half-life of the medication, increasing the risk of respiratory depression. Patient W consumed 2 10-milligram tablets of methadone within the first 12 hours, and the remaining 5 sometime over the next 24 to 36-hour period. That's a really, and he was only 20 years old. It's a really horrible circumstance, but it's a really stark reminder about how doing a friend a favour can seem harmless and straightforward and fine, but it could have really significant consequences. I'm going to now quickly move to AI, because I know it's really topical. There are obvious benefits of AI in the medical space. The benefits promoted by most of the software providers seems broadly to be the notion that it can lighten administrative tasks and increase patient interaction during consultations. AHPRA's published some guidelines, and there are 4 that mesh with the codes of conduct about how practitioners should go about the use of AI in their practice. Some AI tools in healthcare are also regulated by the Therapeutic Goods Act, which regulates therapeutic goods that meet the definition of a medical device, which includes software, including AI-enabled software. if it has a therapeutic use and meets the definitions. That's just something to be aware of. But I'll go back to AI Scribe and talk about that soon. Generative AI tools used in clinical practice, such as AI Scribe, are usually intended for general purpose and therefore don't have a therapeutic use or meet the definition of a medical device, and therefore they're not regulated by the TGA. ARPRA has 4 key principles if you're going to use AI in any way in your practice: accountability, understanding, transparency, and informed consent. The guidelines and the key principles, I'll just expand on them slightly. So accountability basically means that regardless of what technology is being used, the practitioner remains responsible for safe delivery and quality of care, and ensuring their own practice meets professional obligations as set out in the Code of Conduct. Practitioners must apply human judgment to any output of AI. TGA approval of tools does not change a practitioner's responsibility for human oversight and judgment, and all tools and software should be tested to ensure that they're fit for purpose prior to their use in clinical practice. If using an AI Scribe tool, the practitioner is responsible for checking the accuracy and relevancy of the records created using generative AI. As I said, I'll touch on AI Scribe again later. The second principle is understanding. Health practitioners using the AI in their practice need to understand enough about the AI tool to use it safely and in what way it meets their professional obligations. At a minimum, practitioners should review the product information about an AI tool, including how it's trained and tested on populations, what's its intended use, what are the limitations, and what are the clinical contexts where it should not be used. Understanding the intended use of an AI tool is particularly important, as this will inform a practitioner's consideration of when it is appropriate to use the content or imaging generated by AI and the associated risks and limitations, including diagnostic accuracy, data privacy, and ethical considerations. It's also really important to understand how the data that's gathered is being used to retrain AI and where it's located and how it's stored. The third principle, transparency. Health practitioners should inform their patients and clients about their use of AI and consider any concerns that are raised. The level of information for a practitioner needs to be will depend on how and when AI is being used. So, for example, if it's being used as part of software to improve the accuracy of interpreting diagnostic images, the practitioner would not be expected to provide technical detail to a patient about how that software works. However, if a practitioner is using an AI tool to record a consultation, then they would need to provide more information about how the AI works and may impact the patient in terms of its collection of their personal information. So, for example, if public generative AI software is used, personal information may then find its way into the public domain, which is also something that Natasha touched on earlier as well. And the last principle is the informed consent, which is pretty straightforward, that health practitioners need to involve patients in the decision to use AI tools that require input of their personal patient data. And if a patient's data is required for care, i.e. via a recommended diagnostic device, make sure you obtain informed consent from your patient, and ideally to note the patient's response in your health records. If using an AI scribing tool that uses generative AI, this will generally require input of personal data and therefore require informed consent from the patient. It's also particularly important to obtain informed consent for AI models that record private conversations, i.e. a consultation, as there may in fact be criminal implications if consent is not obtained before recording. So, for example, in New South Wales, at least, it is illegal to surreptitiously record anything, including a conversation. And so AI transcription software should include, the use of it should include explicit consent before, at the initial step, before you proceed to use it. And just before I finish up, there's a couple of other professional obligations and ethical issues to consider when using AI, that the board's code of conduct and the use of AI, privacy, confidentiality, where's the data going when it's on a cloud, where is it stored, what country is it in, will you need to update your practice privacy information, how you can support the health and safety of Aboriginal and Torres Strait Islander people and other people from diverse backgrounds, and how they may need to understand more from you about it, and they may have questions about bias and algorithms that are used in AI applications. So if you do practice in any communities that has a large population of Aboriginal and Torres Strait Islander people, it is worth doing some extra research. Yes, complying with the TGA and other regulatory requirements, and holding professional indemnity insurance, and making sure that your professional indemnity arrangements cover all aspects of your practice. And as Natasha was saying earlier, to go with the reputable brands, of which I won't comment because I wouldn't want to say one way or the other, and ones that can provide indemnities. And just to finish up talking, sorry if I'm going over time, the pitfalls of AI software in terms of dictation software, they usually do stem from the storage of patient data, and whether this applies with the APPs, the Australian Privacy Principles. So as I said earlier, you'll need to make sure that your practice privacy policy explains in enough detail about whether the fact that the patient's information will be stored on a cloud, and where that cloud is located. And clinical records are always the responsibility solely of the practitioner. Clinical records must, of course, include notes taken of consults, summaries and letters of referral. Things to consider when using AI to generate clinical records. Anything AI generated needs to be reviewed. AI generated notes need to satisfy the board's codes of conduct, particularly 10.5, accurate and legible record keeping. AI generated notes also need to satisfy the health insurance regulations, which is what I touched on earlier about the use of MBS item numbers and the mandatory information that has to be recorded to fulfill and justify the use of those item numbers. And another sort of practical point of view is whether the AI generated text can be edited and corrected easily, or whether that's going to cause a big hassle and therefore be more of a hindrance than a help. The Royal College of GPs have published a really useful and insightful article on the use of AI, and it is really useful across lots of different specialties. And one point that I read that I thought was an interesting point was that AI recording or automating information can't pick up on the non-verbal cues from patients. It's still emerging, and as far as I'm aware, it hasn't been tested yet at law, but the legislation needs to catch up with AI, and the AMA has published a position paper on that. But as it stands now, the buck stops with the practitioner. So I'll just do my little key takeaways. I think I've covered most of these, so I don't want to go over it again, sorry. Be transparent. oversight is necessary. Make sure you're not breaching any TGA requirements, and get informed consent and make a note of that informed consent. And these are my top tips from each category that I've spoken about. Clinical notes, record everything, including what you routinely provide. Combine communication and documentation. Confirm consent by confirming their understanding. Communication and conduct. The doctor-patient relationship is never equal. Your everyday routine in your rooms or in theatre is not the everyday for a patient. Be mindful of your conduct, manner, expression, and language, as these play a huge part in patient perception and the risk of a complaint. Think carefully before doing a favour for a friend. And AI, oversight is necessary. Make sure you're not breaching privacy legislation or TGA requirements, and obtain informed consent. Questions?
Thank you, Ellie, and also to Natasha. That was absolutely fantastic, especially with the stuff on AI. Due to time, we might now hand over to our consultant. If you're happy to stop sharing your screen.
Yes. Oh, sorry.
No, that's okay. And we're going to have PJ Wormald and Richard Harvey also presenting on their experiences as medical legal experts. Thank you so much.
Fantastic. Thanks, Raywin, and thank you to our two previous speakers. Really insightful. The second part of this evening, and hopefully we won't go for too long, but I think they're really valuable insights. And certainly, I was involved as a medical witness on a case against a colleague, and I was in defending the colleague and learned a hell of a lot about the process and how I needed to improve my practice, and implemented changes to the way I did consent, to the way I got documents signed as a consequence. And I think PJ and Richard have had a vast deal of experience, probably far more than mine, in representing colleagues. So we're going to hear from them for the next 5 to 10 minutes each. And then certainly we'll wrap up with some key points that I think we can all take away with from tonight. So PJ, did you want to start off?
I can do, Elkie, if you like. Let me share my screen. Oh, that's the wrong one. Let me go again. All right. So my talk today is going to be just on the medical legal cases that I've been involved with. Informed consent, failure to deal with a complication competently, failure to properly inform, failure to support the patient, failure to involve appropriate experts are really the important ones. So, I think informed consent, when you are dealing with a case of intracranial or carotid potential, you have to inform the patients of the ultimate complication, which is death or stroke or cranial nerve involvement, blindness and double vision, potentially incomplete resection if you're dealing with tumors, CSF leaks and infections are all, part of those processes, and that sometimes patients will have multiple returns to theatre after such surgery, and that you need to document it. And the way that I've always documented it is with diagrams, college handouts, and making sure that those are appropriate. So just to go through a couple of cases that I was involved in as an expert witness. One was a CSF leak that the surgeon actually failed to inform the patient of the CSF leak, and the patient then developed meningitis. And, that's not defensible. You cannot come back from that as a surgeon. You are in an indefensible position. So, ongoing CSF leak, infection and brain abscess where the CSF leak was not properly treated. And the surgeon said, oh, no, it'll fix itself, it'll seal, don't worry. That's not an accepted way of managing these problems. And really managing this appropriately is your best line of defense. And if you are not capable of doing that management and involving some surgeons that do have, and that particular patient had a really poor neurological outcome from the brain abscess, and you can imagine the settlement for that was huge, and really and really devastating for the surgeon involved. So major vascular injury occurred. The patient died as a consequence of the major vascular injury. There was an inexperienced team, and they were tackling something that they shouldn't be tackling. So if you looked at the team's experience when they created that major vascular injury, should they have taken that case on? And the problem answer is no, they shouldn't. You should really look at particular complicated cases, and you need to evaluate your own level of expertise and your capability of dealing with that particular type of problem that patient has. And you must have that experience to be able to deal with it and to deal with anything that might happen during the resection or treatment of that particular patient. So CSF leak that subsequently led to brain abscess and death. The patient and family weren't informed about the CSF leak. And so the surgeon actually denied that he created a CSF leak, where you can see on the post-op CT scans the obvious cribriform plate injury and the tract that the instrument took into the intracranial cavity. And again, the surgeon, whether you were aware of the fact that you'd created or not, the management of the patient in the post-operative period, completely inappropriate, denying all responsibility for the complication, and then, that obviously leading to the family, because the patient died, leading to the family seeking redress as a consequence of that. And this was a classic case of a narrow frontal ostium, the surgeon probing for the frontal ostium, the skull base being quite thin, the probe just going through the skull base, the surgeon thinking that he'd put the probe into the frontal sinus, but actually had him put the probe into the intracranial cavity, but not recognizing it. Another case was a patient with orbital injury. The surgeon didn't get personally involved. So once the orbital injury had occurred, the surgeon didn't follow that up and say to the patient, listen, we've created this injury. He sort of handed it off to the ophthalmologist and didn't manage the team. So the patient felt abandoned by the surgeon because he didn't remain as the main person taking care of that patient's complication in the post-operative period. So being absent in that post-operative period, once a complication has occurred, just don't do that. Make sure that you are fully involved and take personal care of arranging every additional surgeon or practitioner that might be involved in that patient's care, making sure the patient is aware that you've got the patient's back, that you are looking after every aspect of that complication that you can possibly do to make sure that the best management team is there to help that patient through that complication that occurs. So taking that active interest and really looking after that patient in that post-operative period. So, failing to organize appropriate support. So if you've got an intracranial complication, make sure that you involve the neurosurgery colleagues, make sure that they are consulted and that they are part of that management team. If it's an orbital complication, make sure that ophthalmology is involved and that they're consulted. Physio, if it's required for that patient in the post-operative period. Even if the patient has got a bad neurological outcome, the rehab, the placement of that patient, looking after that care of that patient right up until the nth degree, making sure that you stay involved, that the patient can see you have got that patient's best interest at heart. You are doing everything you can as the surgeon to help with the recovery from that complication that occurred. So I just wanted to show you one of my complications, because I think that always helps. So we had a patient with an anterior cranial fossa meningioma, required a drill out. We drop in the skull base, and we all remember that the anterior ethmoidal artery's got this sort of nipple that comes through. And you can see here we've done a frontal drill out. We've now got our anterior ethmoidal arteries on show. We've got the anterior ethmoidal artery here, so we've exposed it. We're now going to cauterize it, and then we're going to cut the anterior ethmoidal artery. And we need to do this so we can drop the skull base. So we do both on both anterior ethmoidal arteries, both posterior ethmoidal arteries to drop the skull base. So we do that. We cut the anterior ethmoidal artery, not a problem. That's all good. And then we take our drill and we start to drill on the skull base, because we need to create our osteotomies to cut through the skull base. And so we are then making sure that everything's appropriately done. This is the anterior ethmoidal artery on the other side. So we're doing the anterior ethmoidal artery on that side. So we cut that. And then while we're drilling on the skull base to actually create our osteotomies to drop the skull base down, what happens is that the anterethmoidal artery stump on this side wraps around the drill. And so we can see we've got a problem where the orbital fat is exposed, the artery is now retracted. We have a look at the eye, we can see the eyes coming out. So we've got an orbital hematoma. So we now need to go back in. We need to do a orbital decompression. So we'll go back in and we'll do orbital decompression. And then once we've done the orbital decompression, we make sure ophthalmology is consulted, that they're happy with the pressures in the eye, that we can continue on with the surgery. So we do the orbital decompression. We incise the orbital periosteum. And then, so we do that complete decompression. So once we've done the orbital decompression, ophthalmology were comfortable that the eye was not at risk anymore. But now we still need to drop the skull base and take out the meningioma because that hasn't been done yet. So there's our orbital decompression. We can see nicely decompressed. So then we go back in, finish off with our dropping the skull base, cutting the crista galli and the falx cerebri, so we can drop that skull base down and then expose. You can see orbital fat here on the left-hand side as we are still working on that meningioma. And then we get a resection of that meningioma and drop that meningioma down into the nose. I'm just trying to see if I can just speed that up. So we pull that meningioma out and do our repair, and that's it. So patient next day is fine. No problem with the eye, normal movements, full recovery. So everything was well controlled and immediate orbital decompression performed. So just to conclude, informed consent is absolutely critical. You need to document everything. You need to manage your complication appropriately, and you need to make sure that you support the patient completely through that complication. You need to fully inform the patient and the family, and there's nothing wrong with you saying that you're really sorry that the complication happened. That's not an admission of you being doing something inappropriate. It just means that you are showing your empathy with the patient, that you're really sorry that it did happen, and that everything has been done to manage it appropriately. So support of the patient in the post-operative, and manage that entire team yourself. Don't hand it over to anyone else. If you've created the complication, you manage the entire team to look after that. So everyone has complications, and anybody who tells you otherwise is either doesn't operate or is a liar, one of the two or she. And so significant evidence to show that training can significantly benefit outcome patients and reduce surgeon anxiety. So train yourself appropriately, and complications can shake you to the core. They can influence your self-confidence. They can force you to reevaluate your surgical skill level. So take time and take care, and make sure you train yourself appropriately so that you can have the skill set that you need to deal with the surgery. And I'll leave you with a quote from George Bernard Shaw. So thank you for that.
Thanks, PJ, for those insightful comments. Richard, in the interest of time, did you want to get started now?
Yeah, sure. Yeah, 100%. And let me... Tell me if you can see my screen now.
We can see Richard. Oh, there we go. All good.
Yeah, fantastic. So look, I'm glad PJ and I had something slightly different to say here. I was a bit worried that we might say the same thing. Look, here's my reflections. I did a medical legal, like someone else said 15 years ago, reading about how problems unfold in other people's practices is very reflective on your own. And I do think that it's sad that many people only do medical legal work in the very later years of their careers. I actually think the time to do it is when you're a little bit younger. I think the time to do it is when you're still practicing and you've got enough experience, but you're still actively engaged in clinical care. Now, I must say that when I was a trainee, I thought this was supposed to be what medical legal debates were about. But the reality is that this is not so common. So this is someone who's had a sinus problem. I mean, they didn't have much of a sinus problem, but they got a 5 or 6 centimeter shaver track into their brain. That's not really a medico-legal problem. That to me is an error. And I think when errors occur, they should just be called out. No one should, no matter what you put in the consent, you can't just say death, brain injury, stroke, and that then alleviates you from responsibility and obligation of what is supposed to be your professional standard that your rest of your colleagues would be held to. And so no one would want to defend this and say that it's the case. And the other thing that I think for trainees and junior people here, so surgeons, in my opinion, and of course I'm skewed because I'm seeing the cases that have been farmed out for opinions. But surgeons, in my opinion, they don't get sued for not achieving a functional outcome, i.e. not relieving the original dysfunction. So if you've got someone who's still got persistent obstructions, persistent smell loss, unresolved sinus inflammation or dysfunction, they don't really get sued for this. Patients might be unhappy, they spend a lot of money, they make, say, complaints, but they don't really get sued for it. Also, I think surgeons don't generally get sued for not operating, but offering medical therapy, observation, and of course, I exclude neoplasia here, right? Obviously, when people have tumors and things, they should be offered surgery. But for those who, when it's appropriate, but for those who don't, functional impairments, being conservative, let patients driving the decision to actually, go down the surgical route, especially when the surgery doesn't cure the condition. No one is, as I've ever seen a case where the surgeon wasn't operating and wasn't being more aggressive. That's the reason why. So that's a really important thing. So if I had to summarize in 5 minutes, because Alki said I've got 5 minutes, there's 3 reasons surgeons get sued, in my opinion, from reflecting on medico-legal claims. The first one, harm has to be imparted, and then these 3 things are at play. 1, there was really limited or no rationale for the surgery to take place to begin with. And I'll give you a couple examples of that. Someone has a FES operation, PJ, you spoke about getting into the skull base, but then that can happen to anyone, right? And you might have counseled the patient against CSF leak, and then, that can happen. It can cause terrible meningitis. You could die from the sequelae of that. But then when you go back and look at the original scans, the medical legal comes about, there wasn't even sinus disease on the scans to warrant the operation. This is one of the most common things, but harm occurred, and it wasn't until it was reflected upon, they didn't even need the operation. The natural history or alternative or concurrent non-surgical therapies weren't even really discussed. So the patient was taken down a story where they needed to have the operation somehow, but really simple treatments weren't even debated or discussed or thrown out as alternate pathways for a while, maybe even for the patient to come around to the idea that they need an operation. Really important. And then there was a non-disclosure of a suboptimal outcome or error. And you know what? Or deviation from expected care. Now, I'm very careful about using different descriptors there because it's just someone's had a problem. They've scarred up their frontal, they've got a hole in their septum, but no one has said anything about it. The surgeon hasn't declared it. The patient's gone on and had recurrent symptoms. And it's a colleague that has to alert the patient to the fact that there's a big septal perforation or the frontal sinus is occluded. So let me touch on a few of these. So here's someone who was having bilateral green mucus, bilateral congestion, clearly just rhinitis reactions. CT scan was normal. They get a bunch of surgery. Now there's problems. There's frontal sinus occlusion, pain, discomfort. But even those things can happen to people, it happened in a situation where the surgery really wasn't indicated. That's the first thing. So there we go. Here's another one. Here's someone who died from frontal sinus surgery that got in and caused cerebrovascular injury. You can see the defect here. There's a lot of debate around this case about, how quick the surgeon was and other things that happened. But do you know what? What wasn't really debated was that when you look back on the notes, this was the patient's CT scan to begin with. They never had frontal sinus disease. And if you read through the clinical notes, they didn't really have sinus disease. I mean, you can debate the scan as to whether it's a sinus disease for someone with bilateral mucus and congestion, but the patient was using recreational drugs and had a rhinitis reaction. So the chance that sinus surgery was going to help here was very, very low. I wouldn't put it past the colleagues for doing a sinus operation, but perhaps ceasing your recreational drug use and treating the local rhinitis in the nose could have been a pathway first before life-ending surgery for this person. And then finally here's someone who's got a frontal sinus occlusion. The patient had migraines, didn't want to have migraines. I understand people don't want to have migraines, responded to triptans, saw a surgeon that said, oh no, you've got sinus disease. We'll do a sinus operation. Now her migraines are not her migraines anymore. They're constant forehead pressure. And she's got this scan here where she had to come for another opinion because her migraines are worse than her first surgery. And this is her original surgery. Now, her original surgery only shows she's had a Caldwell luck from her childhood. There's nothing wrong with a frontal sinus. And she had triptan responsive migraines. But she became very bitter because she'd seen a colleague who just told her that the previous sinus surgery had scarred up her frontal. That was completely new news to her, and it gave her a terrible sense of maltreatment. Now, you can say that this wasn't required in the first place, fair enough, but the problem came about when the patient discovered they'd had a poor outcome. And the other one that I see sometimes is people have things like a perforation. Perforation occurs, there's crusting, ongoing crusting. Perforations happen, but the patient had to find out about it from another doctor who had to look in the nose. And to PJ's comment, everyone gets complications. And I love quoting Ray Sachs here. Everyone gets complications. Everyone knows how to fix complications. Everyone sees their complications, but not everyone acknowledges their complications. And this is just my last little slide here. Here's one of an orbital injury, and actually PJ discusses this, and it sounds like it might be even the same patient. Someone who had terrible diplopia after what was supposedly an antereth mortal artery bleed, but the antereth mortal artery is entirely in the skull base. So it's really impossible. If you can track this back, you can't pretend you didn't get into the orbit. You can't say I just accidentally got a bit of orbital bleeding. The artery wasn't even there. And when you read this case report from this per surgeon, they didn't declare they had an injury. They tried to cover it up, and the patient and the outcome only occurred to the surprise of everyone afterwards. So in conclusion, to me, patient benevolence, you've got to avoid surgical interventions where the origin of the nature of the symptoms are in doubt. Headache, recurrent rhinitis, don't be doing fess surgery and things like that. We say it all the time, but it's still, I think that's one of the key things. Non-maleficence. If patients have a condition that's not cured by surgery, it's really important to talk to those patients about the natural history of their condition and other medical treatments that's going to be required. I still hear this thing that patients say, well, you can have a turbinate surgery, or you can have a lifelong of using Nasonex. This is your value judgment. That's just not true. If you look at the data, people who have turbinate surgery and they don't treat their allergy, they don't suddenly get a cure from surgery. There is a decline and a reversal of symptoms over time. So ignoring the medical component to many conditions, and then finally open disclosure. When a colleague has to acknowledge your poor healing or complication from a surgical, it comes across as maltreatment to the patient because you haven't declared it. And they'd be sort of my takes on, listening and having to review cases. Thanks, Zach. Alki.
Terrific. Thanks, Richard. Really, really great summary of some great points. So I know we've gone over time. I did want to just speak about 3 minutes of the verbal takeaway lessons from the medical legal case I was involved in defending. And these were things that weren't intuitive to me. And hopefully you can all adopt this in your practice, because I certainly did. The number one thing is the lawyers will find someone who will disagree with your management. So you have to be able to defend your management, not after the fact, but in your case notes beforehand. And the case I was involved in defending was a patient with completed pacification of all the sinuses, and the ENT, who was to represent the plaintiff, said the patient had excessive sinus surgery because they should have just had the maxillary sinuses opened up rather than the sphenoids and the frontal sinuses. And we'd all agree that that is a ludicrous statement, but these are statements that are made by our colleagues. So you can't, I suppose, feel that all your colleagues will have your back. We're always someone that will say something has been done. So you have to be able to defend it, and you can defend it through literature, and you can defend it through attending courses and understanding current standard of care, not care done 50 years ago. The second thing is consent. And, I went through the consent process with my patients and I got them to sign a form. But I think something that Ellie mentioned before is it needs to be understood. And how can we ensure that the patient is understanding it, or at least document that an understanding has occurred, which is something that was brought up against the surgeon. And the way that I think we can get around this is saying in your notes that I have given the patient an opportunity to ask questions about the procedure. They have indicated that they have understood the procedure, and then providing them with a document separate to the generic consent forms that the hospitals provide, which has a dot point of the complications. And at the bottom of it, so it's a second signature that they give, is this signature indicates that I've understood the above procedure, I've understood the options of my care, and I've also understood the risks involved. So they're signing off not on a generic consent form, but actually on a form that you've printed that is then recorded in the patient's note. We can't then argue, or they can't argue that they have the opportunity to ask questions, or they haven't been understood, because that's often something that is played against the doctor, that although they've signed the form, they didn't really understand what was going on. The other thing that I wanted to speak to you guys about was rapport building. And in the complaint, it said the surgeon spent 5 minutes with me during the consultation, booked me for surgery, and I had no opportunity to really understand the treatment options. And I think this is something, as we get busier and we're trying to get through more patients to get our waiting list down, that we all become, I suppose, subject to, and that's rushing our patients. Steve Floriani once said, you've only got about 20 minutes to build rapport with a patient before surgery. And really all the interactions after that, whether they be good or bad, are often based on that 20-minute rapport building exercise. So if you do rush the consultation, you'll miss out on the red flags that may indicate that the patient's expectations don't meet what you can achieve. Red flags are underlying psychiatric conditions, but also that ability for the patient to understand that you've got their best interests at heart. And the final thing that I wanted to say was, as part of the consent in your notes for elective procedures, and Richard highlighted this, the lawyers for the plaintiff said there was no documentation that there was an option of not doing anything for the patient. So that's not talking about conservative treatment with spray. That's the option of living with your symptoms. And as a consequence of that, I've started documenting in my consent. I've discussed the option that is a quality of life procedure. There's an option of living with the symptoms and not performing and not doing any further management. The option of conservative management with the topical treatments, or the option of surgery. And so that's something that I took away from that medical legal case that I was involved in. So I think probably we're well over time, but we should open the floor probably for a few questions, Raywin, for about 5 minutes, and then probably close the evening for the sake of everyone.
Yeah, or any comments from Ellie and Natasha on the presentations as well. I'm sure, Ellie, that's your sort of lived experience, what PJ, Richard and Alki have just presented.
Absolutely, yeah. Definitely, particularly about plaintiff firms being able to find a gun for hire. There's always going to be someone, because they're paid well, who will give the plaintiff what they need to start their cause of action.
Simon, you have your hand raised. Simon is a medical legal rep for RACS as well.
Thanks, Robin. I think that there's a lot of recurring themes that have come up with all the speakers tonight, and certainly the lawyers here will be probably far more aware of the legal cases than us clinicians are. And for those of you that have never actually read Rogers versus Whittaker and Chapel versus Hart, I would actually urge you to download the full High Court decisions on them, because it gives you a huge amount of insight as to how judges look at these cases. And there's a very classic comment where one of the judges says they were unable to put themselves in the shoes of the doctor, but they were able to stand in the shoes of the patient. And there's this sort of expression of the right of self-determination rather than firm consent, that the patient has got a right to ask more questions and a right to seek a second opinion. And Alki mentioned about medical care. I also document that the patient has been offered the chance to get a second opinion from a surgeon who might be more conservative than me and who also might be more aggressive than me or more experienced than me. And that comes into Chappell versus Hart, where poor Dr. Chappell was criticized for not saying that there were other surgeons around that had done more cases than he had. And the three tests which sort of come out of these two cases are, but you have to satisfy yourself, is the reasonable patient test. You know, what would any normal patient wish to know, you know, given a set of circumstances? And then the reasonable doctor test, what would any reasonable doctor ask about? And that anticoagulation case, you know, it's classic. Most doctors would ask about anticoagulation and document it. And then relevant to the case that Alki was talking about is the particular patient test. And if you're starting to getting the red flags that a patient is worried about surgery, pushing you into surgery, or has got other red flags like recreational drugs or anything else, you have to pay particular attention to how that self-determination would differ for that particular patient as opposed to another patient who might receive your standard consent. And Alki was talking about documentation. And when you've got patients where you're worried about that particular patient test, bring them back a second time, as well as offering them the chance to ask questions, because consent isn't achieved at a single period in time from a legal perspective. It's an ongoing longitudinal process, which only ends when they go to sleep on the operating table. So see them back a second time, document the fact that they've had another chance to ask questions. And at the end of the day, I think the lawyers will say, you can't be perfect. You can't get it right all the time. And all you can do is your best.
That's awesome. Thank you, Simon. Are there any other questions while we have Ellie as well as Natasha and PJ, Alki, Richard, Simon? Has anyone got any other specific burning questions?
Yeah, the only other thing I would say why maybe someone wants to ask a question is just, I mean, unless patients have tumors or life-threatening problems, let them drive the decision to operate. And I tell you, patients have the slightest inkling that they, you know, they're 35 years of age and they maybe need a septal and turbinate surgery. I have just no interest in pushing them to do an operation. There's nothing about an operation in acquired adult onset nasal obstruction that's going to be sort of amazingly curative, and they may be associated with other medical treatments. It's just not life-threatening, and really, I think there's just an enormous, for some people, lack of maybe confidence or ego that they can't let the patient go out of their rooms knowing that they may seek a second opinion of someone who's more likely to sell them into the operation. I think you should. Patients aren't ready, just let him go. Let him come back to you for the surgery. I think that's a really important thing. Let them drive it. Apart from those who are likely to suffer harm if the condition's not treated. But that's very, very few people, at least in rhinology.
Well, thank you, everyone. We've gone over time, but it's been so worth it. Particularly Ellie and Natasha, thank you for your expertise. For presenting to a bunch of surgeons on a Wednesday night. It's been really incredibly helpful. Also to PJ, Richard, Alki, and Simon for putting your clinical perspective onto that. I think it's been really helpful for all of us. It's quite scary, Ellie, to see that 15% increase in complaints. So this is something that we all need. This has been recorded. Ellie and Natasha, please let me know if you were not happy with that. It does go on our website where only members can access it, but please let me know if you would not like us not to put your section or Simon, PJ, Alki, Richard, please let us know. But otherwise, thank you all. Our next webinar is in 2 months' time, and we'll certainly send you information about that. Thanks, everybody.